Recommends programs such as the one we're proposing. It includes assessment, screening, referral to treatment, case management, and monitoring in a supportive environment so that healthcare providers will feel encouraged to seek help at the earliest sign of need. California needs a statewide program where physicians and those trying to intervene with the physician can get the help that they need. I want to share the following facts about this program. Number one, there will be no cost to the state or to taxpayers. It's paid for by participants. Two, anyone can call the program and get help from the program approaching and intervening with a physician when there's a matter of concern. Three, doctors with these disorders, just like everyone else, will not self-refer to get help unless programs are confidential. The names and identities of program participants shall remain confidential unless the participant is not meeting requirements or conditions of their treatment agreement, or they entered the program as a condition of probation, medical board action, or are subject to restrictions on their practice due to substance abuse issues. And four, there are many safeguards that exist in the physician health program. None of these safeguards now exist in any coordinated manner without a program. To protect patients, we must find an effective way to safeguard from healthcare professionals who may be impaired by their abuse of alcohol and other drugs. This requires a coordinated statewide program, the ability to collect and report outcome data, and the resources to provide oversight. Private options, operating independently in multiple locations around the state, simply cannot provide the coordination the state needs. Without a contractual relationship between existing resources and the California Medical Board, there is simply no ability to have the effective coordinated structure that has proven to be successful.
Thank you.
A well-designed system of assessment. Thank you.
Thank you. Let's move to additional testimony and support.
Janice Norman on behalf of the California Medical Association in support. Happy to answer any questions.
Thank you.
Jennifer Simoes with the Medical Board of California. The board would like to thank the author and sponsors for taking amendments to include the board-approved elements, and we respectfully request dry vote. Thank you.
Thank you. Additional testimony and support, please.
Doug Chiappetta with the Union of American Physicians and Dentists with AFSCME in strong support. Just want to commend the author on putting a bill forward that should have been addressed a few years back. I really want to take note with what Ms. Galgiani said, that the physicians are the only profession that doesn't have a diversionary program in the state, and that really needs to change today. Thank you.
Good morning. Connie Delgado with the California Hospital Association, here in support and also recognizing that this bill will not only help the physicians in need, but also provide patient protection. Thank you.
Thank you.
Mr. Chairman, members of the committee, Randall Hager for the California Psychiatric Association. For all the reasons you've heard here today, we commend this to your support.
Thank you. Appreciate that. Let me ask if there is additional testimony and support. Hearing and seeing none, let me ask if there is testimony in opposition. Please proceed.
Mr. Chairman, members, Ed Howard, Senior Counsel with the Center for Public Interest Law at the University of San Diego School of Law. We regrettably are opposed to the measure. We did not engage full-on in opposition in the Senate, hopeful that negotiations with the sponsor and author would resolve our concerns. The amendments that, as we'll discuss in a moment, that your committee is suggesting are welcome, although we don't understand one. And they do address important issues, but there's one very, very critical issue that remains to be addressed. To provide the platform by which to discuss the need for the remaining amendments, it's important to provide some additional information about the troubled nature and history, not just of the Medical Board's program, but all of the diversion programs. Quote, a University of California, San Francisco expert in treatment of drug and addicted healthcare professionals resigned as a volunteer consultant to California's diversion program for nurses. telling a state Senate panel the program is untenable and in some cases dangerous. That was in 2011 from the LA Times. That was 8 months after 140 nurses and pharmacists were, as it turns out, being given erroneously clean results on their tests. The analysis mentions the LAP program for lawyers. In 2011, the Bureau of State Audits audited that program, found that only 11% of lawyers completed it. It had, quote, poor monitoring procedures. It had, quote, failed to send needed reports to the state bar. One was as late as 52 days after a failed drug test, and one participant failed 20 times before the bar was notified. When it comes to the medical board program previously failed not one, not two, not three, not four, but 5 audits, all with the same issue. All of the program's most important monitoring mechanisms were failing. That's a direct quote from the Enforcement Monitor's report in 2006. There is, quote, an absence of enforceable rules and standards to which participants and personnel are consistently held. And as the Enforcement Monitor found also, they identified randomly, because there isn't evidence of patient harm in the documents of the diversion program unless a doctor self-reports it. But the Enforcement Monitor then found, quote, a self-referred physician who relapsed several times during August and September of 2003 and over-medicated a patient and was caught carrying unnecessary medications on his cart. And there were 5 additional times that the Enforcement Monitors found that physicians, while in the program, were, and allegedly passing, were in fact caught with drug and alcohol in their system while providing patients. Why all the background? The background is important because in response to those scandals across the latitude and longitude of the diversion programs, this legislature passed SB 1441, which was a bill to provide consistency in the application, transparency, and accountability of these programs all across all of them. And one of our primary objections to this bill has been that it does not, in the opinion not just of us, but all of the consumer and patient groups that are on the opposed side of this ledger, it does not yet fully and consistently abide by the uniform standards in one very important way. We heard the talk about confidentiality earlier. It's important to note that even with all the confidentiality in the whole world that the prior program had, and notwithstanding the analysis correctly foreshadowing that there are a very large number, potentially, of physicians who are drug and alcohol addicted, in 2005, only 232 doctors were in this program. Only 232. And the reason is because if you're drug and alcohol addicted and you know that relapse is a part of recovery, it's pretty unlikely that you're going to go to the licensing agency in order to get your help. There's a very high risk there, no matter how much confidentiality there is. So just a moment of historical context. At its peak, we're talking about $1.5 million program then that helped 232 doctors. But the critical piece of the uniform standards that still is at best confused in this bill, notwithstanding the welcome amendments from your committee, Mr. Chair, have to do with confidentiality, not disclosing information to the public. The uniform standards permit confidential participation when it comes to the public. But what remains at best confused and at worst contradictory is when information in this program is transmitted to the board, and can the board still confidentially take action against a licensee who may have hurt somebody while in the program? And in that regard, the amendment that the committee requested and that the senator was gracious enough to take does help. But if you look at, this is page 5 of the bill, 2340.6, subdivisions C, D, and F, they all deal with confidentiality, but they deal with them in subtly different ways. So, for example, subdivision C, lines 31 through 32, talk about oral information reported to the board shall remain confidential. That's all fine. However, confidentiality regarding the physician and surgeon's participation in the program and related records shall not apply if the board has referred a participant as a condition of probation. Does that mean that if you self-refer into the program, that the board doesn't get to know about it? Likewise, if you look at subdivision F, that's on page 6, lines 4 through 10. It says, laudably, participation in the program shall not be offense to any disciplinary action. This, ... This section does not preclude the board from commencing disciplinary action against a physician who was terminated unsuccessfully from the program. However, that disciplinary action may not include as evidence any confidential information unless authorized by this section. And when you look at the rest of the section, it is unclear what information the board can rely on in attempting to discipline somebody who may have hurt a patient while in this program. That is the clarity that we seek. The uniform standards are absolutely crystal clear that if you're in this program, you cannot hide, Mr. Chair. You cannot hide. If the board knows, if the program knows that you are flunking and are a risk for patients, it needs to be abundantly clear in this bill that the board can not only be notified, but can use that information as a part of any disciplinary action. Otherwise, the notification is useless. With that amendment, while we have obviously conceptual problems with the bill, that's the underlying it. We do respectfully request that that be clarified, and it's of vital importance to patients, Mr. Chairman. And
All right,
members.
thank you for your testimony. I appreciate that, and we'll allow the senator to respond to that because I believe we did discuss some of those issues. And I know you did say you appreciated some of the amendments, but we will get back to that. Let's continue with testimony in opposition.
Jacqueline Serna on behalf of the Consumer Attorneys of California. I'd just like to echo Mr. Howard's sentiments about the amendment. We do appreciate the committee's work and the author's willingness to take the clarifying amendments that we think make the bill workable, in particular number 3, so we do appreciate that. However, we would like to see this issue with the uniform standards addressed as well, and would then look at the bill again. At this moment, we're still opposed unless amended, but look forward to working with the author. Thank you.
Thank you. Additional testimony in opposition, please.
My name is Michelle Montserrat Ramos. I'm with Consumers Union Safe Patient Project, and I'm from Los Angeles. Why do I care about substance abusing physicians? Well, this issue is personal to me. I am here representing the dead. My fiance, Lloyd Montserrat, died in Los Angeles Hospital with no cause given for his death. He was 36 years old. In order to find out how he died, I had to hire a pathologist for a private autopsy. The results revealed that Lloyd died from surgical mistakes, untreated infection, and sepsis. Upon further investigation, I learned Lloyd's doctor had a long arrest record. Lloyd's doctor had a long arrest record, including felony possession of crack cocaine and prostitution. In reviewing the testimony from the police officers, it showed that Lloyd's doctor had a recently released parolee in his personal vehicle. He had crack cocaine and drug paraphernalia in his vehicle. When the officers asked him why he was there outside a known drug den, Lloyd's doctor said that he was there looking for a hooker. He was looking for sex. It was obvious that Lloyd's doctor had no concern for his own personal safety and well-being. So how could he have any concern for Lloyd or his other patients? He couldn't. Who was Lloyd Montserrat? Lloyd dedicated his brief life to public service. He was a vote director for the DCCC, a director at NALEO, a chief of staff for the city of LA, a respected political consultant, and even organized nurses for SEIU Local 660. He made great contributions to the city of Los Angeles and across the state, and his loss is still felt in our communities. Unfortunately, the state failed Lloyd. What is at stake here? Consumer protection is at stake. Since the end of the abolished confidential physician diversion program, there have been some patient safety measures that have been put in place to protect Californians and your constituents. We now have information on those substance abusing doctors that became known to the medical board by means of a public document on the board website. With the passage of SB 1441 in 2008, the uniform standards for substance abusing licensees in the state of California, we finally have some patient protections. The medical board now has the use of an interim suspension order which they can use if a doctor is practicing while impaired or is found to be dangerous to practice. If this bill is passed, the interim suspension order is gone. The SB 1441 Uniform Standards is currently California law and covers everything: evaluation, monitoring, and discipline. If a doctor truly wants to end his addiction, the tools are there and the program is strict, while at the same time there's consumer protection set into the program. Lloyd's case was not a random tragedy. There are doctors across the state who have been found to be treating patients while impaired. There's a Glendale doctor who's been addicted to drugs for years, and once forced into rehab and put on leave for his hospital, he just jumped from clinic to clinic to continue to work. A Bakersfield doctor who was a meth addict had sexual relations with his patients and then assaulted them. A Sacramento ICU doctor who is treating patients while drunk. A San Diego doctor who passed out at work. A Camarillo anesthesiologist who was stealing anesthetic medicine from the hospital and then putting people under anesthesia while impaired. Who is looking out for the patients? Well, the medical board isn't, so we turn to you. If our regulatory board does not meet its mission to protect consumers, then we turn to you, our elected officials, in order to protect us. Lloyd didn't have the right to know that his doctor was in a confidential program, so it cost him his life. This is Lloyd's final resting place. Please don't send another Californian to an early grave. I'm asking for your no vote on SB 1177. Thank you.
Thank you. Additional testimony in opposition.
Good morning, Mr. Chair, committee members. My name is Tina Manassi, and I'm from Roseville, California. I'm a survivor and a victim of medical harm caused by a doctor who battled an addiction to alcohol. He was in a secret program, the now defunct confidential diversion program run by the Medical Board of California. His participation in the program was kept hidden from me and countless others. In 2002, Dr. Brian West performed a surgery on me that I was not a candidate for. 4 months after my surgery, he closed his practice down and abandoned me and all his other patients. Nearly 14 years after my botched surgery, I still suffer from excruciating pain, spitting sutures, gaping holes, disfigurement, and a mutilated body. I will be forever reminded of the harm this doctor caused me and how the Medical Board of California did not protect me. I know many patients who were victims of the same physician while he was in the secret program. In fact, some have died. A few years before my surgery, unbeknownst to me, Dr. Brian West performed a no-consent surgery on the late Becky Anderson and left her with her intestines exposed. Your staffers were able to see her pictures and were appalled. While she was in the hospital fighting for her life, he went to make his rounds to check on her and was arrested on a DUI car accident. The medical board didn't pull his license, didn't pull him from practice. Dr. West settled out of court with Becky for the maximum allowed in California, which is $250,000. She passed away in 2008. While Dr. West was in the secret program, he repeatedly tested positive for alcohol and failed to follow the program. He even had his worksite monitor, his own office manager, a person he could hire and fire, lie for him on his AA records, stating that he'd attended meetings when in fact it was a lie. However, he was never pulled from practice. He was also able to convince the Medical Board of California to give him several chances to be in the secret program. This doctor was able to game the system and harm more patients throughout the state of California. This was clearly a physician who had a chronic history of alcohol abuse, who was allowed to operate on me and others. Had this information been available to us, we wouldn't have chosen him. And some of these patients might not have died, and I wouldn't have been injured. His license was revoked 7 years after my surgery. SB 1177 would allow physicians accused of substance abuse to be diverted into a confidential substance abuse program, and that information will be kept secret from their patients. As soon as a physician is required to enter a substance abuse-related program, that information should be publicly reported on the Medical Board's website. Further, substance abusing physicians who have been referred by the Medical Board into treatment should be required to disclose that to their patients. The involvement of substance abuse should never be a cause to allow secrecy or reduce public reporting requirements, such as information about actions taken by the board on doctors' online profiles. Additionally, the program included in this legislation for substance abusing physicians should not be associated with the California Medical Association or with any nonprofit associated with the CMA or with any entity associated with past administrators. This fox guarding the henhouse approach led to the failed model of the medical board that the medical board used in the past and should not be repeated. The paramount priority of the medical board is patient protection, not protecting doctors. Former NBC Medical Board President Dr. Richard Fantozzi said in 2007, quote, "To hide something from consumers, something so blatant, is unconscionable today." Committee members, it's still unconscionable today in 2016. If it were your mother, father, brother, sister, daughter, son, or your grandchild, would you want a doctor who has a substance abuse problem that's in a secret program to treat or operate on them? Wouldn't you want this information? Wouldn't you want to make an informed decision? How can you do that with a secret program like this? California patients are at risk, and I urge you to oppose this bill. Thank you.
Thank you. Thank you for your testimony. Let me ask if there's additional testimony in opposition. Hearing and seeing none. Senator, let me allow you a chance to address some of the concerns. I know some of the issues raised in the opposition testimony does refer to an old program, which was a diversion program that was in place from 1980 to 2008. I know the program that you are implementing now, the Health and Wellness Program, and thank you for accepting the committee amendments, which will bring light to those that either fail or withdraw from the program, and those will all be reported, and sunshine will be available for those. But, Senator, please let me allow you the opportunity to respond.
Yes, it is the goal of this bill that it is not a secret program like the secret program that was referred to before. I feel badly for the incidents that you have talked about, and it has been our goal all along to make sure that we provide a way for those physicians who want to help themselves, who are serious about helping themselves, who are serious about making sure that they do not injure their patients, to have a place where there are some structures in place to ensure that there is discipline at the end if necessary, and that there is transparency. Right now, a physician can choose not to get help. A physician can also choose to seek help in a private facility where there will be absolutely no transparency and absolutely no oversight. It is our belief that if a physician believes that by taking a step to be involved in a non-private program, rather this program, if no matter what that physician has to disclose that they're entering a program, that they will not enter this program, but rather they will enter the private program where there is absolutely no medical board oversight at all. That's the balance that we're trying very hard to meet, and that is why we've accepted the committee amendments. I would like to turn over to Janice Norman from CMA to speak to some of the amendments that we have taken in committee here that add to amendments that we took on the Senate side as well.
Thank you, Senator. Please.
Mr. Chair, thank you. Appreciate all the work of the author and your committee staff on this issue. As mentioned before, the bill is structured consistent with the existing program that's for the osteopathic physicians. Osteopathic physicians and allopathic physicians have parity with regards to their license. So when you refer to doctors, you really are referring to either both an allopathic physician or an osteopathic physician. Existing law within the osteopathic physician allows for confidential participation for self-referrals. And that's important to note, that when people talk about the confidentiality, it's talking about the confidentiality for the individuals that do not yet have an impairment. They simply have an illness. When you look at the spectrum with regards to substance abuse disorders, they begin as an illness and at some point convert to an impairment. The balance that I believe the author has struck and that the committee has struck is that if there is the hint of impairment at the point in which the public is at risk, the medical board is notified and has the tools available to it in order to proceed. So I would like to point out sort of a couple of things just for points of clarification and to help set the stage. One, this is not a diversion program. If someone enters this program, they can be disciplined at any time, even for the reason in which they entered the program. That is the definition of a diversion program. A definition of a diversion program means that you cannot be disciplined for the incident that got you enrolled in the program in the first place. So that's point number one. Point number two, the medical board itself discontinued the failed program. I'll repeat myself. The medical board itself discontinued the failed program and then set about the work of how to self-correct. That work was completed this fall when they adopted principles about what they would need to do and what controls and structure and infrastructure they needed to ensure that a new health and wellness program, not a diversion program, could be constructed in a way that would be successful. As testimony from the medical board, we have met those principles, and one of those principles, again, is self-referral. That's why the bill is narrowed, and the self-referrals are, again, anyone who doesn't have a practice restriction on their practice related to substance abuse. And then two, and I think this is incredibly important and good work by the committee, it also allows for, even if you're entered the program as a self-referral and a complaint is entered and it rises to the level of an investigation, the medical board, with the amendments taken here today, will have the ability to inquire of the program, is Dr. Norman participant in the program? The medical board, the program will have to say yes or no. The program will have to say yes or no in answer to that question. And then under the bill, page 5, line 37, nothing in this bill prohibits the medical board from obtaining the evidence that they need in order to effect discipline with regards to the scope, the course and scope of his or her practice. So we understand there is a philosophical concern from the opposition. We understand that they do not wish to have this program revived or a program revived. But here is the bottom line. The bottom line is what they are asking to do is to continue having physicians that have an illness to not be able to come forward and engage with the state. Studies have proven that programs for physicians that have some coordination with the state are the most successful. That information is pointed out in your analysis. This bill is good for consumers in the sense that it provides the medical board with the information and authority to make the appropriate decisions to protect patient safety. It provides physicians that have an illness, not an impairment, with the ability to seek help in the best way forward. And again, it allows for the medical board, and it addresses all of the concerns with the failed program, which the medical board thoughtfully completed this fall.
All right. With that, let me turn to members on the dais for questions. Hearing and seeing none.
Mr. Chairman, if I may, I beg the indulgence of the chair, but Mr. Norman read from a subdivision but trailed off at the end, and that particular subdivision, the last words of it are exactly what we're talking about and exactly the kind of amendment that we're seeking. The last words of subdivision D are, the subdivision reads, because what we're talking about is not whether you're public when you enter the program, but can the board be notified and use information that's developed in the program to discipline you, as is provided in the uniform standards, as is the supporters said you would be able to do. But look at the final words. Nothing in this section prohibits, requires, or otherwise affects the discovery or admissibility of evidence in an action by the board against a physician and surgeon. If the language ended there, they would be right, but it doesn't. Based on acts or omission within the course and scope of her practice. When you are in the program and you flunk, here's uniform standard number 10. One of the consequences is referral for discipline. These documents that are created during the time that you're in the program are not within the course and scope of her practice. This language does not permit, certainly does not clearly permit, the board to be able to use as evidence documents and other information they created during the program. If that is the intent of the senator and the supporters, we welcome it. But it's unclear to me that that's their intent. But if it is, there's no reason not to amend the bill to make that crystal clear. It's critical to patient protection.
And I know the senator will look at that and take those comments to heart. I did give you the indulgence without a member question to look at that. But let me allow the senator now to close. Senator, would you like to close?
I respectfully ask for your aye vote.
Okay, with that, it has a motion from Mr. Bro, a second by Mr. Dodd. This is a do pass as amended. Thank you for accepting the amendments to appropriations. Madam Secretary, call the roll.
Salas.
Aye.
Salas, aye. Bro.
Aye.
Bro, aye. Baker. Baker, aye. Bloom. Bloom, aye. Campos. Campos, aye. Chavez. Chavez, aye. Daly. Dodd. Dodd, aye. Eggman. Gatto. Gatto, aye. Gomez. Holden. Jones. Jones, aye. Mullen. Ting. Wood. Wood, aye.
That measures out 10-0. We'll hold the roll for additional members to add on.
Thank you.
Thank you, Senator. Let's go ahead and move to our last item. This is file item number 8, SB 1155 by Senator Morrell. Senator Morrell.
Thank you, Mr.
I believe
Chair.
this has a support from each side. So it's been moved by Mr. Jones, seconded by Mr. Bro.
I've got
Senator
about a
Morrell,
half-hour
please.
speech I'd like to give, but I think on that, I respectfully ask for your aye vote, please. Thank you.
Well, let's go ahead and move to testimony and support.
Laura Zuniga with the Contractor State License Board. Support.
Thank you. Additional testimony and support.
My name is Francie Kaler. I'm the past president and current legislative chair of the California Association of Licensed Investigators. Veterans have served our country on our behalf very well, and therefore the California Association supports the intent of SB 1155 to waive initial fees for honorably discharged veterans. Returning vets have many expenses, and it's important for the state to at least provide this benefit to them, to assist them. Private investigators have a separate fund, and if private investigators are included, then we feel certainly that additional expense will be covered by that fund for private investigators only.
Thank you. Additional testimony and support.
See and support.
I'm sorry, can you repeat that for the record?
Nushin Movasagi on behalf of the California Board of Accountancy and support.
Thank you. Additional testimony and support. Hearing and seeing none, let me ask for testimony in opposition. Hearing and seeing none, let me turn it to members on the dais. And let me ask for clarification from Senator. Senator, you did accept the amendments that are outlined in the analysis, correct?
Correct, we did.
Thank you. All right. Questions for members on the dais. Hearing and seeing none. It's been moved by Mr. Jones, seconded by Mr. Bro. Senator, would you like to close?
No, I respectfully ask for your aye vote. Thank you very much.
Okay, with that, this is due pass as amended to Veterans Affairs. Madam Secretary, call the roll.
Salas.
Aye.
Salas, aye. Bro. Bro, aye. Baker. Baker, aye. Bloom. Bloom, aye. Campos. Campos, aye. Chavez. Chavez, aye. Daly. Dodd. Dodd, aye. Eggman. Eggman, aye. Gatto. Gatto, aye. Gomez. Holden. Jones. Jones, aye. Mullen. Mullen, aye. Ting. Ting, aye. Wood. Wood, aye.
Okay, that measure is out, 13-0. We'll hold the roll for additional members.
Thank you.
Okay, at this time, we're going to go ahead and call the absent members. Let's just go in file order. So, Madam Secretary, just call the absent members. SB file.
Mr. Chair, just a point of order real quick.
Oh, yes.
We haven't taken a motion on Monning yet.
Okay. Yeah, we have lots of measures on call, but we could go ahead and skip to file item number 5. Do I have a motion to move Senator Monning's bill, SB 945? All right. Moved by Mr. Jones, seconded by Mr. Bro. That is a due pass to appropriations. Madam Secretary, call the roll.
Salas.
Aye.
Salas, aye. Bro. Bro, aye. Baker. Baker, aye. Bloom. Bloom, aye. Campos. Campos, aye. Chavez. Chavez, aye. Daly. Dodd. Dodd, aye. Eggman. Eggman, aye. Gatto. Gatto, aye. Gomez. Holden. Jones. Jones, aye. Mullen. Mullen, aye. Ting. Ting, aye. Wood. Wood, aye.
Okay, that measures out 13-0. Members will start at file item number 1, SB 270 by Mendoza. Madam Secretary, call the absent members.
Bloom. Bloom, aye. Campos. Campos not voting. Eggman. Eggman, aye. Gomez. Mullen. Mullen, aye. Ting. Ting, aye. Wood. Wood, aye. Gomez. Gomez, aye.
Okay, that measures out 9-6. Let's move to file item number 2, SB 465 by Senator Hill. Madam Secretary, call the absent members.
Eggman. Eggman, aye. Gomez. Gomez, aye. Holden. Ting. Ting, aye.
Okay, that measures out to 11-0. Let's move to file item number 4, SB 896 by Senator Nguyen. Madam Secretary, call the absent members.
Daly. Eggman. Eggman, aye. Gomez. Gomez, aye. Holden. Mullen. Mullen, aye. Ting. Ting, aye. Wood. Wood, aye.
Okay, that measures out 12-1. Let's move to file item number. Let's move to file item number 5, SB 945 by Senator Monning. Call the absent members.
Daly. Gomez. Gomez, aye. Holden.
Okay, that measures out 14-0. Let's move to file item number 7, SB 1132 by Senator Galgiani. Call the absent members.
Bloom. Bloom, aye. Daly. Eggman. Eggman, aye. Gomez. Gomez, aye. Holden. Mullen. Mullen, aye. Ting. Ting, aye. Wood. Wood, aye.
That measures out 14-0. File item number 8, SB 1155 by Senator Morrell. Call the absent members.
Daly. Gomez. Gomez, aye. Holden.
That measures out 14-0. File item number 9, SB 1177 by Senator Galgiani. Call the absent members.
Daly. Eggman. Eggman, aye. Gomez. Gomez, aye. Holden. Mullen.
Yes.
Mullen not voting.
That measures out 12-0. Let's take up the consent calendar. Call the absent members.
Daly. Eggman. Eggman, aye. Gomez. Gomez, aye. Holden? Mullen? Mullen, aye. Ting? Ting, aye. Wood? Wood, aye. 14-0.
Consent calendar's out, 14-0. With that, we will hold the roll open for 5 more minutes to allow Assemblymember Holden and others to add on, at which point we will then terminate the committee hearing for today.